is up in 5, 4, 3, 2, 1. And we are live, coming to you from an undisclosed location somewhere in Northeast Ohio. I'm Josh McClay, a.k.a. O'Malley of O'Malley's Adventure. That's Joel Fichter, Magistrate, City of Massillon, Massillon Municipal Court Judge Candidate. And this is O'Malley Live. I want to thank everybody for joining. Whether you're watching live or in post, the number to contact the show is 330-809-1924. Or you can email us at o'malleysadventure@yahoo.com. Joel, how you doing, my friend?
Doing well, thank you. Thanks for inviting me, Josh.
Good. It's good to have you on. So I'm interviewing candidates, sort of put a name and a face together.
Mm-hmm.
Tell me a little bit about your background. How long have you been in Massillon your whole life?
Yes, yep. I'm 60 years old. I was born in the old Massillon City Hospital at the time in 1959. Grew up on the west side of Massillon. Went to St. Barbara's School. And after that, I went to Lauren Andrews and then Washington High School. I'm a 1977 graduate of Washington High School. I was actually outstanding senior boy that year. Went on to Bowling Green State University, where I received my Bachelor of Arts degree in political science was my major, and I had a business minor.
Okay.
And I then went to so I graduated cum laude from Bowling Green State University in 1981. And then I entered the University of Akron School of Law. And I graduated in 1984 from the University of Akron, but I actually finished my school in 1983. Law school, if you go full-time, is a 3-year program. Mm-hmm. And after my first year, it was law school is difficult, not like college. And I decided to take a few summer classes that summer after my first year. And so I took 2 classes and did well, and I realized if I do that next summer, I would actually... it would count as a whole semester of law school. Right. So after my second year, I did the same thing. I took 2 classes that year. So I was able to finish up in 2.5 years of law school instead of going all 3 years. So nice. I actually got done with law school in December of 1983, which was wonderful because then I took the bar exam in February, and I was able to study in the winter months as opposed to the normal process, which is you graduate from law school in May and then you take the bar exam. Mm-hmm. So actually, when I graduated from law school in May of 1984, I had already taken the bar and passed it, and actually was a lawyer on my graduation day, whereas almost all of my classmates had to then take the bar exam and wait 6 months before they became lawyers. So that was 1984. I got out of law school. My last year of law school, I worked for a law firm it was in downtown Massillon. It was Sturgis and Kurtzman, okay. Which was in what is now the Massillon Museum. That was the old Giltz building. Our office was up on the 3rd floor of the Massillon Museum. Mm-hmm. And I practiced law with those gentlemen for 20 years because, till 2004. We actually moved out of downtown Massillon in 1986. They built an office up on Aaronwood Avenue near what is now Campbell Oil, and right. There's some law offices in there now. But so I practiced law with that group for 20 years, mm-hmm. And it was a general practice firm. We did a lot of everything. I did criminal, civil, real estate, workers' comp, bankruptcy. I practiced in all of the municipal courts in the area, mm-hmm. and a lot of the common pleas courts in the area, Stark County, Tuscarawas, Summit, Wayne, Carroll, Tusk, I already said that, Jefferson, Cuyahoga. We went up to Youngstown, Trumbull, and Mahoning counties. So had a really broad background in law. When I worked for that law firm, and then I went out on my own for 3 years. Right. In 2004, I left the law firm and went out and practiced law for myself for a period of 3 years in downtown Massillon. Mm-hmm. So,
transitioning in college, mm-hmm. what made you decide to venture into law?
Well, I actually, it's a little bit unusual because people usually don't know what they want to do. But right. I was in 6th grade, and I like to talk a lot, and a lot of people... And I like to argue. Right. And a lot of people just said you'd be a good lawyer, and that kind of planted the seed. Nothing too serious. But when I was in high school, I took a real interest in government classes and mm-hmm. political science classes. And so when I went to college, I had a pretty good idea what my plan was. And I knew it could change. And as a matter of fact, I thought it would, because most kids think they know what they want to do.
Sure.
And they get to college and everything changes. But I went to college with the intent of going to law school. And you have to take an exam to get in. It's the LSAT. I think they still call it that, the law school admissions test. And I took that my senior year in college at Bowling Green. Did very well and got into the University of Akron. So it was just kind of a natural transition. It's what I thought I wanted to do, and I did, and I'm really happy.
So, after someone becomes an attorney, what made you decide to either do defense or prosecution?
Okay. Well, first of all, the only way you can do prosecution is if you get hired by a government agency to work for the government, to be a prosecutor. I never had the desire to do that. When I started, when I went to law school, my original intention, my first year, I thought I wanted to be a corporate lawyer and do all corporate law and go work for a corporation.
Right.
But after 1 year of law school, the way the University of Akron Law School was at the time is they try to give you as broad a background and education as you can. You take a little bit of everything, and I just decided I like doing a lot of different things. I like doing estate planning and wills. I like doing defense work, defending people, whether it's just a small traffic case or a more serious crime. I like doing workers' comp, where represented injured parties in workers' compensation. I did some defense work. I did some plaintiffs' work. But it was really great with the fellas that I worked for. There were 5 of us, and we were able to. We had a really, really nice law firm, and when people would come to us and they had this particular problem, if I couldn't handle it, one of the other fellows in the firm would do it, and likewise, we kind of, and I wouldn't say we specialized in anything, but I did a lot of real estate transactional work, but still enjoyed being in the courtroom, and I just like the idea of doing a lot of different things, which was a perfect transition for becoming a magistrate, because you really have to know a lot of different areas of law. People think if you're a magistrate, all you have to do is know criminal and traffic law, but there's a whole nother side of the law, civil work, eviction work that I do, and I did a lot of eviction work as a lawyer, representing both landlords and tenants, and now I'm in the middle of those disputes, and so I have a very good background.
So, you're an attorney. What makes you decide to transition into to be a magistrate?
Well, that was never in my plan. It never ever was in my plan to become a magistrate. I never thought about wearing a robe. I was happy practicing law. I was happy for 20 years with the law firm, and then I was happy for a little over 3 years working for myself. But the opportunity arose. Judge Richard Kettler was on the bench at the time at the Mass Municipal Court. The 2 judges were Judge Kettler and Judge Elam. And Judge Kettler was retiring, and the magistrate at the time, Roland Centrone, ran for the position, and he was elected.
Okay.
And when he got elected in November of 2007, that left a vacancy in the magistrate's position. And a couple people came to me and said, "Joel, you know, you're a Massillon guy. You know the people. You know the players. You know the community. You'd be good at this. You seem to be level-headed, and I've represented people on both sides of we always say both sides of the V, like Smith versus Joan. I've been on the plaintiff side. I've been on the defendant side. I really did just about everything you could do as a lawyer, and I don't want to overstate it, but I couldn't. I've never done anything have to do with intellectual law, which is like patents and trademarks and things of that nature. And I never was a prosecutor, except for the fact that I was kind of a prosecutor for the Heartland Behavioral Health Care. I used to do hearings. They were called commitment hearings, and I would kind of be the prosecutor in those cases. But don't want to equate that to a criminal prosecutor. It wasn't. But the position became available, and people approached me about it, and I had to kind of make a fairly quick decision, because Judge Centrone was elected in November of 2007, and he was going to take the bench. He was going to move from a magistrate to a judge on January 1st. And so I had less than 2 months to think about it, and I talked to some people, talked to my family, and I thought, that would be a good opportunity. I was very, very hesitant to do it. I was really really hesitant to leave my practice of law because I'd practiced law for over 24 years.
Right.
And I was really nervous because what if this bombs and I lose my client, if this bombs and I try to go back into my private practice and all my clients have gone somewhere else. So there was a lot of thought involved, but I took the position, and I remember when the reporter for The Independent interviewed me, and he said a lot of times this is a stepping stone to be a judge. Do you have any ambition to being a judge? And at the time, I just thought, no, that's not even crossed my radar. And I didn't.
Right.
But then a few years ago, I started thinking, and I knew that Judge Centrone has to retire because of his age,
Right.
unfortunately. And so I knew there was going to be another opening, and I thought, what better transition than after 12 years of being on the bench to go from a magistrate to a judge.
So what are the age limits as far as how is once you hit a certain age, or you're done, or can you move to other areas?
No. What the requirement is in Ohio for judges is there is a law that says if you are over 70, you cannot run to be a judge.
Okay.
Okay. But once you're a judge, you can actually sit on the bench for the rest of your life if you're physically and mentally able to do it. But you can't run as a sitting judge. So Judge Centrone, he was 62 when he ran 12 years ago.
Right.
And then 6 years ago he ran again. He was 68. He's probably going to get mad if I give his age, but it's a public record. But he's 74.
Yeah.
And so he's over 70, so he can't run. But as you see, he was able to finish out his term. It's not like when you turn 71 and you're on the bench, they throw you out.
Right.
It's just if on election day, if you're going to be over 70, you can't be on the ballot. So it's a forced retirement for him. We say you're aged out, but he certainly he can work every day if he wants by going to different courts throughout the state of Ohio. There's always judges that are on vacation, or something comes up that for an emergency they need a judge, or there might be a conflict of interest in a case.
Sure.
Sometimes a judge becomes ill, and they're going to be undergoing some type of treatment for 2 or 3 months, and there's a vacancy. So he can sit as long as he wants. We call that sitting by assignment. You get appointed to go to a particular court, and obviously you get paid, but he would be drawing his retirement. So I don't know what his plans are if he's actually going to do that, but I know several of the judges. Judge Stuckey, who is my age, actually. He's my age. He retired several years ago, but he does an awful lot of work. I think I talked to him recently, and I think he said he's been in over 50 counties of the 88, the state of Ohio, that he's sat in doing judicial work.
Now, that would be an interesting gig to have, because you're in Massillon and you're dealing with a lot of the same people.
Right.
You're going to get a big flavor of what's out there.
Yeah, absolutely.
Let's talk a little bit about the divergency program.
Oh, diversion program.
Diversion, that's it. Yes.
Program.
Yes.
Divergent's a movie or something,
Yeah,
isn't it? Or something like that. Our sons have watched it, but the diversion program, Josh. What that is, that was started. A lot of the courts in Ohio have been doing that, and the whole theory with the diversion program is, we know that people make mistakes. I've made mistakes. Everybody makes mistakes, and you hate to have something stay on their record forever and ever. If it's a fairly minor offense. A diversion program is where you come into court and you have to plead guilty to the charge. You can't plead no contest. You're not fighting it.
Right.
You come in, you have the right to a lawyer, but you come in and you plead guilty to the charge. And then what we order you to do, we find you guilty, we give you a fine, we give you a jail sentence that we suspend. And then in lieu of that, what we do is and I'll give you an example. Every case is not eligible for diversion.
Okay.
First of all, our diversion program was started, I believe, in 2010. I'm almost positive. We're into the 10th year. There's another magistrate in the court, Mandy Kuhn, and she actually was very instrumental in starting the program. The two judges, Judge Elam and Judge Centrone, asked her to set up a program based upon, she did some research with some other courts, is what they were doing. I can't say if ours was the first diversion program in Stark County between Massillon, Canton, and Alliance. It may have been. I kind of think it was, but I don't want to say for sure that I know that. But Mandy did a lot of research, set up the program, and the whole theory is, first of all, if it's a violent offense, you can't go into the diversion program, because the end result of the diversion program is if you do what the court orders you do. If you follow all of the orders that we give you, and 90 days after you plead guilty, excuse me, the case is actually dismissed and removed from your record as though it never occurred.
Okay.
And there's a little bit of difference between sealing records and expunging. But this, when the person pleads guilty, we don't, even though there's a finding of guilty, it's not docketed. It's not a final determination by the court. We take that guilty plea and then we kind of put it on the back burner. We give them a sentence and then we kind of push it to the side here and say, this is what the sentence will be if you mess up.
Right.
But in lieu of that, if you're a first-time offender, it's called a first-time offender diversion program, we will still we'll normally order you to do community service.
Okay.
We'll order you to go to some type of a class, either an alcohol or drug education program, or if it's a theft offense, we'll make you go to a theft diversion program that ComQuest has. They have set that program up. It's a one-day class that we order them to go to. They hold them on Saturdays. You have to pay the cost of the class. It costs $200 to go to that one. It's like an 8-hour class. It costs $200 maximum. They look at your household income. If you're indigent, it can be less, but it will not ever be any more than $200.
Okay.
So you go to the class, you perform community service hours, and then very importantly, you have to behave for 90 days. You can't have any new charges during the 90-day diversion program. So say if you're in for a theft and it's your first offense, you've never been convicted of any type of a criminal or alcohol-related offense.
Right.
Now, if you've had a speeding ticket, that doesn't apply.
Right.
But we're talking about a crime or alcohol-related offense. We make you behave for 90 days, and if you do that at the end of the 90-day program, if you follow all the court orders, then the case is dismissed and removed from your record, and we never enter the guilty plea and the guilty finding.
Sure.
So it literally, it's not swept under the rug. It goes away, but then when you're asked on your employment application or college application, have you ever been convicted of a crime? You can say, no, I've never been, because the conviction does not go into effect if you do what you're supposed to do. And that's where we have the problem.
Right.
We have some people that either they don't do their community service, they don't go to the program, or what happens a lot of time is they mess up again and they get another charge within 90 days. And I always tell them when we put them into the program, you got to be perfect for 90 days. You can't be close. Any new charges, you're out of the. It's not the right way of saying we flunk out of the program. We remove you from the program.
Sure. But
again, if you're in for a theft offense and you would get a speeding ticket the next week, that doesn't remove you from the program because that's not a crime.
Sure.
Speeding is not a crime.
Right.
But if you would get an OVI charge or any new theft offense, we have a lot of young kids that we put into the program for underage alcohol consumption.
Right.
We see, and we don't see defendants until they're 18. People ask a lot of times about juveniles. We don't. If you're under 18, you go to the juvenile court.
Sure.
So once they're 18, they come to us. So we get a lot of kids, especially in the spring around graduation. You see the parties. So you have 18, 19, and 20-year-old kids that get charged with underage consumption.
Right.
If they have no other past problems legally, we'll put them into our diversion program. That really helps because these kids are a lot of them are going to college, they're trying to get a job, and they got to put this on the application.
And then
you've got children go to college. You know, one of the things they ask you when you're trying to get financial aid or student loans, have you ever been convicted of a criminal offense? Have you ever been convicted of an alcohol or a drug-related offense?
Sure.
So we'll put, and we don't discriminate against older. It's not just for kids, but if certainly underage consumption it would be 21 or under.
Right.
But if somebody in there, it doesn't matter how old you are. But if you get cited for possession of marijuana, a minor misdemeanor, or possession of having a pipe with residue in it, we put those folks in the program as well. And people make mistakes. We understand that. So we try to.
So there's a road to redemption.
Absolutely. That's a perfect way of putting it.
So, and you say that's specific to an age, or it's not specific to an age?
No. And anybody can go into the program. Yeah, we obviously the underage consumption. Those are for kids that are only 18, 19, or 20. And the majority of the drug charges we get are younger kids. I would say probably 25 or under.
Sure.
But certainly we see an awful lot of 50, 60, 70-year-old people that get picked up for having a joint or
being a dummy,
pipe, being a dummy.
Right.
But things there are certain things, as I said, you cannot. It's not a first time offender diversion program for any we can't put you in the diversion program for a speeding charge or for an OVI.
Right.
It's only there are certain, and a theft charge, we can put you in a diversion program if the amount of the item or the item stolen was $100 or less, we will put you in a
Okay.
diversion program. But if you steal more than 100, we won't. Or certainly if you steal $999, we're not going to put you in.
Right.
Because if it was another dollar, it'd be a felony. If it's 1,000 or more, it becomes a felony. But this is only for small. We're not there to try to cut everybody a break that goes out and steals $800 worth of something.
Sure.
Certainly they break into a home. That's if it's a violent offense, we don't even discuss it, because with a violent offense you have a victim. But certainly if and I forgot to mention this, but if it is a theft offense, and say you stole $90 worth of something from, we see a lot of them from Macy's, Kohl's, Target, Walmart. And for anybody listening or watching, this isn't a reason not to steal, but all these stores have video cameras. They know what you're doing. It really
Right.
makes the prosecutor's job and the police job easy when it's all right on film. And they get, you get a kid going in there with their football jersey on, that says Fichter on the back of it, number 12 or something, and you steal. They're pretty easy to identify. But the thing is, with those, if it's $100 or less, we'll put them into the program. But we also always make sure that if there is a victim, the victim gets compensated. So if they stole $90 from Walmart,
Right.
we make them pay the $90 back to Walmart, because Walmart is the victim. But yet, in reality, people always say, well, you gotta put them in jail when they steal. You gotta yes, to a certain degree you do. But first of all, that we don't have the jail room.
No,
to,
we
to,
don't.
to put them in but. So you don't want to say, I would never say no harm, no foul, but I would say sometimes everybody gets a break. You give them one break, but if you steal the second time, you're going to jail.
Right.
And if we do put you in the diversion program, it's called a first time offender program for a reason. You only get to do it once.
Right.
And if you've done it in another court, there are ways to find out if you have, but we will not.
You won't
You
entertain
don't get
it.
two bites at the apple.
Right.
Never.
So my last question is, would you consider moving to a higher court?
And you'd never say never, but I actually think I could say never. I wouldn't. Part of the reason is, number one, it's hard to believe, and I'm not on the downside of my legal career, but I'm 60 years old. If I win this election now, in 6 years I would run again, and in 6 years after that I would be 72. I wouldn't run. I have way more experience in municipal court. I feel much more comfortable. I'm Massa Municipal Court, Western Star County. That's me. That's who I am. I don't think that I would ever have the desire to move up and be a common pleas court judge. And there's a lot of different types of judges in common pleas court. People think the only common pleas court judges are Judge. Well, there's 4 females and a male. Frank Forcione is the male, and then there are 4 female judges, and that's a little bit of a joke, because I think Frank grew up in a household where he had, I think he might have had 4 sisters, and he was the only boy, and now that he's on the bench, he's got his 4 colleagues are women. But Judge Forcione, then you have Judge Hopt, Judge Heath, Judge Farmer, and Judge, who am I forgetting? Oh, good Lord, somebody, Judge Carissa Hartnett. Good Lord, she'll be upset with me that I forgot her name. But what they do, they're just at a different level of the people that they deal with, and I'll explain that in a moment. But when I was saying about the common pleas court, there are 5 common pleas court judges in Stark County in the general division.
Right.
But then there's also the probate division, which is Judge Dixie Park, and then we have the family court, the domestic relations division, which has, I probably am not going to get them all right, Judge Hall, Judge James, Judge NIST. I think that's the 3 of them. So there are actually in Stark County Common Pleas, there are 8 judges, 5 in the family division, 9, 5 in the family division, 3 in the domestic relation division, and 1 in the probate division. But I don't think I would feel comfortable doing that. I feel comfortable doing what I'm doing now, and
Right.
I'm pretty confident I could say I would never want to move to a different court.
So, before I forget,
Sure.
because everybody wants to know, what is the difference between a magistrate and a judge? What's the
Judges can do three things that I'm not permitted to do.
Okay.
Other than that, I can and I do in our court do everything that the judges do, and I'm not
Okay.
overstating that. It's just a fact. Um, I cannot perform wedding ceremonies as a judge or a magistrate. I can't do that. Now, if I wanted to get a license with the state to do it, because I know people will do that,
Right.
you can become I don't want to call them a minister, but you can perform ceremonies.
Ceremonies,
But
right.
I can't do that with the power that's vested in me by the state of Ohio as a magistrate. I don't have any authority
Okay.
to marry anyone. Second thing I'm not permitted to do is I'm not permitted to sign a search warrant.
Okay.
If the police come in and they need a search warrant executed signed so that they can go search somebody's home or business or whatever because of a suspicion of a crime, I'm not permitted to sign that. So if one of the judges aren't there, they're not going to get the search warrant signed. I'm not permitted to do that. And the third thing I'm not permitted to do is I'm not permitted to hear jury trials in our court unless both parties would consent. If both parties consent, then I could. But everything else that a judge does in our court, my two bosses are great. Well, three, because I have one at home that's my wife. But the two that I have at work are great. They don't give me cases and say this is what you're doing. They don't see the cases. I have the job of everybody that's charged with any crime
Okay.
or traffic offense in the Massillon Municipal Court jurisdiction. If they come to court, the first appearance they make is me. That's who they see. I'm
Okay.
the first person they see in the judicial system. Whether it's starting at a seatbelt speeding all the way up to OVI with the traffic cases, and then you start with your criminal cases as low as minor misdemeanor, disorderly conduct, up to criminal trespass, and up to the first degree misdemeanors, assaults, domestic violence. Everything that comes into the court, I'm the first person they see. And when felonies come to our court,
Okay.
the first person they see is me, because we don't call those arraignments. We actually call that's an initial appearance.
Okay.
Someone charged with a felony comes to me for their initial appearance, and what I do is I read the charges against them. If it's a misdemeanor, I ask them to enter a plea. A felony, we won't let them enter a plea at the initial appearance
Okay.
stage. We force them to go to a preliminary hearing, which is the second step in the felony process. And I don't hear a lot of the preliminary hearings, but many times for Judge Centrone, when he's not available or if he's at a conference or out, I will hear the preliminary hearings for him. So I've got a lot of experience with preliminary hearings.
Okay.
And then what happens, and I said at the initial, with the misdemeanors, whatever traffic offense or crime, if they plead if they plead not guilty, then it's my job to set their bond.
Okay.
And so I set bonds. I don't have to go to the judge and say, hey, what bond do I set? I just set the bond. If they want to plead no contest or guilty, then I find them guilty, or if they plead no contest, I could find them not guilty. But if I find them guilty, I sentence them. And I sentence them to either fines, costs, community service, jail, suspended jail time, whatever. But that's what I do. And some people think that all I do is the judge tells you what to do. Like, we have a meeting every morning and they say, Joel, this is what we don't have time to have meetings every morning. There are many days I
No.
don't see either judge. I just come in. My job is to take the files and get them, either get the case done. A lot of times the judges are happy if we can resolve a case at the first time.
Sure.
We get people come in from all over the country for different things. They're in town. They might be working on the just in town, staying at Belden Village. They get in a little bit of trouble. They want to get the case done. We resolve it. We're not going to make them come back from Texas 2 weeks later for disorderly conduct or something. Now, if it's a violent crime, then we won't resolve it at the first step, because the primary thing we want to do is make sure that the victim is protected. So
Sure.
if it's domestic violence, we never resolve the domestic violence on the first day. That's always has to go to the second step, because we need to make sure that hopefully it was a one-time incident. But if it's something, there's a pattern, and we have to send somebody to jail, we will. Or if we have to send them to counseling, anger management, drug or alcohol counseling, we do that. So we are and it's kind of a corny phrase, because now not now, but for the last 30 years, there's been a show called The People's Court.
Right.
But we really are the People's Court. We're the overwhelming majority of people that their first taste of any legal experience is in the municipal court level. So I see every type of, and Stark County, God bless us, we are a melting pot. We have every
Sure.
type of person, every type of income, race, color, sex. We we see it all. And my it's not a philosophy, but my demeanor is I'm not naturally a mean guy. But if you're going to be a jerk to me, then
Right.
and then I'm not going to be as nice to you as I would somebody else. But I try to explain what the situation is, and I also understand that most of the stuff we're doing, it's not. If somebody comes in on a speeding ticket, or even they got in a bar fight or something, and if nobody was hurt and they've got a clean record, a 40-year-old guy got a little tanked, that's not the end of the world. And I understand that because I
Right.
represented people just like that
Right.
for 24 and a half years. So I understand that every case isn't Supreme Court worthy, and certain cases are, and you got to treat those a little differently. But we also understand that, and I don't want to say we're an assembly line, but we have such volume in our court that we have to keep the cases moving.
Sure.
We just have to. That's why my voice is the way it is, because I talk
Yep.
so much in the morning, but yet I talk fast because I got to get done with my morning court, so that, not that I have time to eat, but so that I can be ready to go for the afternoon court. Because,
Right.
and it's a very, my campaign literature says that I've presided over more than 70,000 cases.
Right.
I think that's low. Now I haven't had 70,000 trials. That would be ludicrous. But on any given, I know the we've had a Monday recently where we had 45 arraignments in the morning. That's a lot of arraignments.
Wow.
I mean, it's a lot of arraignments that you're
Right.
dealing with. And certainly anybody that comes in, and if they believe that they're not guilty, that's what I encourage them to plead. And I had them this morning. I don't know what to do. What do you think I should do? And I said, I can't give you legal advice, but I'll tell you this. If you're not sure how to plead not guilty.
Right.
Because then you have time to think. You can talk to a lawyer.
Sure.
But once you plead guilty, you can't undo that.
Yeah, there's no backs.
And if it's a speeding ticket, it's not the end of the world. But certainly, I would never let anybody plead guilty or no contest to a domestic violence at the initial stage, at the arraignment. I wouldn't do that, because for sure they're going to jail. And I think before they go to jail, they ought to talk to a lawyer.
Sure.
Because they might be able to, and we see. I mean, I see people that are just good human beings that make a mistake. They get caught for speeding or even something a little more serious. A kid, had a joint. The good kid never been in any trouble. They're in their third year of college and they were out with their buddies and they got caught for having a joint.
Right.
Stupid, dumb. But I also realize that that's not the end of the world.
Sure.
We try to help the people. I've had many, many people leave the courtroom and they thank me, even though I ruled against them or found them guilty. But my nature is not to scold you and belittle you, and
Right.
most people don't need that. And I always say it: the overwhelming majority of the people I see, I only see them once. Now I might see them twice for a speeding or something, but
Right.
if somebody gets picked up for a theft offense, I would guess out of every 10 thefts that I see, defendants for thefts,
Right.
8 of those I'll never see again.
Right.
But the 2 that I'll see again and again and again.
Right.
And it's the same way with OVIs.
Right.
The overwhelming majority of people get one OVI, they learn their lesson, it scares them to death, and I'll never see them again.
Right.
But then you get the guys or girls, second time, third time, and that's why the law is written that if you get a second or a third, each time you get convicted, the minimum sentence goes up.
Sure.
So.
Well, that's all I have. Do you have anything that you want to put out there to the people?
Only that, and I'm not a politician, and I was glad you didn't ask me any politician questions because I'm just Joel Fichter. I'm the guy that grew up on the west side of Massillon. I know the west side of Massillon very well. I know Western Stark County. I'm not out there pretending to be holier than thou, but I practiced law for 24 years. I've represented every type of client that you could imagine, and for the last 12 years, I've been doing the same thing that the judges do. My experience is, and that's what I think generally people are looking for. They want somebody experienced. I have 12 years. Actually, I have more than 12 years on the bench. I've been on the bench as a full-time magistrate it'll be 12 years here at the end of December. But prior to that, I actually had 3.5 years where I would fill in for Judge Centrone.
Right.
When he would take a vacation to go to a conference, I would be hired for a day or two or a week. I filled in for Judge Elam several times when he was out, and I was the acting judge. So I've done it for a long time. I'm very comfortable with what I do, and I just feel that my experience and reputation, my character, integrity, makes me the candidate that's the most qualified to be the next municipal court judge at Massillon.
Well, if that's a wrap, again, people get out and vote. If you don't use your rights, eventually you will lose them. That is my philosophy. We have rights for a reason. Exercise them.
Amen.
Exercise
When I say
them,
vote,
please.
You don't have to vote for me, but vote. That's what I say. And it's not what I'm supposed to say, but that's the way I feel. I want you. I certainly want your vote. I want them to vote for me, but
Sure.
but it's important that we all vote, not just in the judicial race, but that and
Across
local
the board.
politics is the it's where it all starts, and that's really who can help you is the locally, and I don't mean the judges can help you, but who you vote for city council or township trustee. That's the people you're going to get the most response from, more than no offense to any congressman or president or senator. You send them a letter, you're probably going to get a form letter back. But if you call your city councilman or you call your township trustee, you're going to get a phone call back, and they're going to give you an answer, good or bad, but at least you have that connection, and that's why it's important to get the right people in office. And I think I'm one of those. I think I'm one of the right people.
Outstanding.
Thank you
Thank
very
you much for your time.
Appreciate it.
I have nothing left this evening. There might be one tomorrow, but I'll put something out in the morning if there is. I'm going on vacation next week. I'm going to take some time off. Monday evening before the election, there is going to be a live stream from right here, and we are going to do coverage of the election. Thank you for your time, sir.
Hey, you're welcome.
All right.
My pleasure.
Until next time, stay sharp, keep a tight shot group, and rock on.
Wonderful.